There's a thing that many criminal defense attorneys do when they get pulled over. Ask any lawyer who works in legal defense, any public defender, anyone who's spent significant time inside courtrooms watching how these cases actually unfold. Ask them what they do when an officer walks up to their window and asks if they can look around the car. Most of them decline, immediately, without a long pause, without guilt, without the nervous qualifier of, I don't have anything to hide, but they just say no, calmly, clearly, like someone who was asked a question they already knew the answer to before it was asked. And here's what gets me about that. These are people who understand the law from the inside, people who've spent years in courtrooms, who've read the relevant cases, who know how the system actually works when things go sideways. Their entire professional experience is built around understanding what happens after these moments on the side of the road. And that knowledge, that specific, accumulated, outcome-based knowledge, is exactly what produces the immediate, unhesitating no, which raises a question worth taking seriously. If the people who understand what happens next consistently decline, what do they know that most drivers don't? Let me tell you about a guy named Chris. Chris drives 40,000 miles a year for work, 3 years in the same car. He knows every inch of it. Careful driver, nothing on his record. The kind of person who genuinely has nothing to worry about. He got pulled over on a Thursday afternoon. Minor thing, following too closely. The kind of stop that should produce a warning and 5 minutes of your time. The officer was professional, ran everything clean, and then right as the stop seemed to be winding down, asked the question. "You don't mind if I take a quick look in your car, do you?" Chris thought about it for maybe 2 seconds. He was sure he had nothing to worry about. Gym bag, water bottles, work folders, a jacket. He'd driven this car every day. So he said sure, of course. During the search, the officer found a small prohibited item in the gym bag. Not Chris's. He had absolutely no idea it was there. His best guess afterward was that someone who'd borrowed the car a few weeks earlier had left it without him ever knowing. Didn't matter, because Chris had consented, which meant what was found was legally obtained, which meant the months of legal process and expense that followed flowed directly from 2 letters. Sure, I'm not telling you that story to frighten you. I'm telling it because it illustrates something that experienced legal professionals understand at a level most regular drivers never have reason to think about. You don't have to have done something wrong for a search to create problems. You just have to not know what's in your car with the same certainty you think you do. And honestly, nobody knows their car with that certainty. Think about it genuinely for a second. Think about everyone who's been in your car in the last several months. Every time you gave someone a ride, every bag placed in your trunk, everything you carried for someone else, everything thrown in the back seat and forgotten about. Now think about whether you'd stake your clean record on a thorough search of all of it. Many experienced defense attorneys wouldn't, and the reason why changes how you think about that question entirely. Here's what experienced legal professionals understand that most drivers don't. The Fourth Amendment protects you from unreasonable searches, but consent can significantly limit later legal challenges. If you voluntarily agree to a search, the constitutional question largely shifts. The officer doesn't need to establish probable cause, doesn't need a warrant, they just need your agreement. And once that agreement is given, what's found through that search is, in most circumstances, legally obtained. Challenging the search itself becomes significantly harder because it was you who opened the door. This is why consent is considered so valuable from an investigative standpoint. It simplifies an otherwise complex legal situation. In many situations, experienced attorneys believe the legal risks of saying yes outweigh the potential benefits. Your agreement does a tremendous amount of legal work in that moment, and most drivers hand it over without understanding what they're handing over. Saying no, on the other hand, changes the legal landscape. It doesn't mean a search can't happen. Officers can search a vehicle when they've established probable cause, with a warrant, or in certain other specific circumstances that vary by jurisdiction and the specific facts of the situation. But declining consent means any search that does occur can potentially be examined later on legal grounds. Your no preserves options. Your yes can eliminate them. Experienced defense lawyers understand this distinction clearly, which is why many of them decline immediately. But here's the part I find more interesting than the legal mechanics themselves, and it's the piece that most people skip past. Why is saying no so hard in practice? Because it genuinely is. Even knowing what we just covered, even being intellectually aware of your right to decline, actually doing it in the moment, with an officer standing at your window, with every social instinct in your body telling you that cooperation is the correct and decent thing to do. It's harder than it sounds on paper. And understanding why it's hard is what actually makes you capable of doing it when the moment arrives. There's a concept in social psychology called authority compliance. It's been studied extensively since research in the 1960s first drew attention to it. The core finding is that most people, when faced with a request from a perceived authority figure, comply at rates that significantly exceed what they would predict about themselves. If you ask someone beforehand, would you agree to a vehicle search if an officer asked politely? Most people say no. Of course not. Why would they? And then the moment comes, and they say yes. Not because they're not thinking, because authority compliance is wired into human social behavior in ways that don't feel like compliance in the moment. They feel like being a reasonable person, being cooperative, being someone who doesn't create unnecessary friction over nothing. The officer is polite. The request sounds simple. The social script for friendly request from an authority figure produces a very specific automatic response in most people. Agreement. Attorneys who've spent careers understanding what that agreement costs have actively developed a different response. They've replaced cooperate with the social script with protect my legal position. And when they're in the car, they apply the same thinking to themselves that they'd apply to a client. That mental shift is available to everyone. It just requires knowing it before the moment comes. Let's talk about how the consent question actually gets asked, because it doesn't always arrive in the form you might expect, and recognizing it in every version is part of being genuinely ready. The direct version. Mind if I take a look around? Obvious, easy to recognize. The assumptive version. I'm going to check the trunk real quick. Not framed as a question, stated as a plan. Many people respond to this by simply opening the trunk, because it sounded like something already decided. The benefit version. If everything's clean, this takes 2 minutes and you're on your way. This makes consent sound like it benefits you. In reality, if everything is clean and you decline, you're also on your way, with your legal protections intact. The social proof version. Most people just let us check when they've got nothing. This uses implied peer behavior as pressure. The guilt inversion version. You've got nothing to hide, right? So this shouldn't be a problem. This reframes a constitutional right as suspicious behavior. But think about that last one honestly. Do experienced attorneys have things to hide? Do judges? Do law professors? These are people who understand this area of law better than almost anyone, and many of them decline consent searches as a standard practice. Not because they're hiding anything, because they understand what consent legally means. Every version of this question is asking for the same thing, and the response to all of them is the same 5 words. Officer, I don't consent to searches. Here's what tends to happen after you say that, and this is where people unnecessarily panic. The officer may seem surprised. They may rephrase the request. The warmth that was present in the interaction may shift to something more formal. The energy of the stop changes. None of that means you've done something wrong. None of it means danger. It's what happens when someone receives an unexpected answer and adjusts. What you do through all of that is stay exactly the same. Calm, polite, clear. You don't repeat your answer defensively. You don't explain your reasoning. You don't apologize for exercising a right. The attorneys who do this regularly don't flinch when the energy shifts, because they know their position is legally sound and practically appropriate. They've been in this situation, or situations exactly like it, enough times that the social pressure doesn't override the clarity. You can develop that same clarity. It just requires knowing it before you need it. Now, what happens if the officer indicates the search will proceed regardless of your answer? This is where an important distinction matters. Consent typically does not change your legal protections when it comes to searches that proceed on other legal grounds. If an officer has genuine probable cause, if they've observed something, if there's a specific legal basis for the search, a search may lawfully proceed without your consent, depending on the specific circumstances and jurisdiction. The law here is genuinely complex and varies significantly by location and situation. But if that search proceeds, you want a clear record that you did not consent. That record is what preserves the possibility of later legal examination of whether the search was properly justified. So the phrase adjusts. I'm not consenting to this search, but I will not physically resist. Both parts carry weight. The first establishes non-consent clearly. The second ensures safety and full compliance with lawful authority. Do not touch the officer. Do not attempt to block any part of your vehicle. Do not raise your voice or create any physical confrontation. Comply entirely with the physical process while clearly stating your non-consent verbally. This is the professional approach. Your safety in the moment and any legal questions that follow are 2 entirely separate arenas. The roadside is not the place to resolve legal questions. That's what attorneys and courts are for. Let me walk through the full practical sequence now. Because understanding the principle is one thing, having the actual words ready, in order, when your adrenaline is up and someone in uniform is standing at your window, that's the preparation that actually helps. When the lights appear, hazards on, pull over safely, park the car, engine off, hands on the steering wheel. Interior light on at night. Wait for the officer. Do not reach for anything before being asked. When they arrive, calm greeting. Neither overly friendly nor cold, just a regulated, normal person. Do you know why I stopped you? No, officer, I'm not sure. Not a guess, not a suggested explanation. When asked for documents, provide them without hesitation. If reaching toward the glove box, narrate it. My registration is in the glove box. I'm going to reach for it now. When the consent question arrives in any form, officer, I don't consent to searches. Calm. Once. No additional explanation, no qualifier. The qualifier, but I don't have anything in there, is understandable. It feels like you're being reasonable, but it extends a conversation that is better ended at 5 words. If asked why you're declining, it's just my preference, is more than sufficient. You don't owe a legal explanation for exercising a right. When the stop seems to have concluded, documents returned, ticket or warning handled, but the conversation continues. Am I being detained or am I free to go? Most drivers have never asked this question. It requires a direct legal answer. Either you're free to leave, in which case you thank the officer and go, or you're being detained, which triggers different considerations and warrants. I'd like to remain silent until I can speak with an attorney. If detained and you say that, mean it. Stop talking. Let's run some variations. Because the standard daytime highway stop is one version, real situations have more shapes. What if there are 2 officers, one at your window and one on the passenger side? Standard procedure. Both sides of your vehicle are being observed simultaneously. Your behavior and your phrases stay exactly the same. The only adjustment is your awareness that the whole car is visible from 2 angles, not just the driver's side. What if you're a passenger in someone else's vehicle? Passengers are legally considered part of the stop in most jurisdictions. Depending on your state, you may be asked to identify yourself. You can be ordered out of the vehicle. If a search occurs, what's near you and associated with you is relevant. Don't volunteer information. Don't narrate the situation on behalf of the driver. If asked questions about the vehicle or its contents, I'd rather not answer questions without an attorney present. What if the request comes at your front door rather than your car? Your home carries the strongest constitutional protections. Without a warrant, officers generally cannot legally enter. Speak through a partially open door. Do you have a warrant? Without one. I'm not comfortable allowing entry without a warrant. Calm, clear, not aggressive. What if you're stopped late at night in an isolated location? Hazards on immediately. Slow visibly to show acknowledgement. Drive at clearly reduced speed toward the nearest well-lit, populated area. Call 911 while doing this. I've been pulled over and I'm driving to a lit area for safety before stopping. A legitimate officer will understand this concern. The key is communicating your intention clearly rather than simply driving without explanation. What if the consent question comes after a long, friendly conversation and you're already relaxed? This is actually the most important scenario to be ready for. The relaxed, friendly, mid-stop conversation is precisely where the request tends to land most effectively, because your guard has naturally come down. You've been chatting. Things seem fine. The question arrives in that context and feels like a small, easy, unremarkable ask. It's the same ask it always was. The 5 words are the same 5 words. Officer, I don't consent to searches. The context doesn't change the phrase. The friendliness of the interaction doesn't change the phrase. The only thing that changes is how automatic the words need to be, which is why practicing them matters more than people think. What if something has already been found, or a search has already happened, before you knew any of this? First, one situation, in isolation, doesn't determine everything that follows. What happened, in what sequence, under what circumstances, all of that matters enormously, and the details of your specific situation are something only a qualified attorney in your jurisdiction can properly evaluate. Second, contact an attorney as soon as possible. Not to fight anything necessarily, to understand your specific situation with someone whose job is to protect your interests, not the investigation's. Third, stop discussing the details with people who aren't your attorney. Well-meaning conversations spread in directions nobody anticipates. Let me come back to the attorneys for a moment, because I think there's something worth sitting with about why their behavior looks the way it does. Experienced defense lawyers have spent careers watching what happens after these moments. They've represented clients who said yes because they were certain nothing would be found. They've worked through cases where the outcome turned on a consent that took 2 seconds to give and months to deal with. They've sat across from people who made a fast decision without understanding what they were deciding. And then they go home, get in their own cars. And when they get pulled over, because they're human and it happens, many of them decline immediately. Not because they're preparing for some dramatic legal confrontation, not because they assume bad faith from the officer, but because they've seen enough outcomes to understand that in many situations, the legal risks outweigh any practical benefit from saying yes. Think about what saying yes actually gets you when nothing is found. The stop ends a little sooner. Consent typically does not change your legal standing in any positive way. There's no formal benefit recorded anywhere for having agreed. You simply traded a protection for a few minutes. The legal calculus, when you understand it clearly, is what makes the immediate decline the professional habit it is. Here's what I actually want you to take from this video. Declining a consent search is not aggression. It's not an accusation. It's not a declaration of guilt or a challenge to anyone's authority. It's the calm, lawful exercise of a constitutional protection that exists for everyone, designed for everyone, and used regularly by people who simply understand what it's for. The phrase is 5 words. The delivery is calm. The protection it preserves is real. Officer, I don't consent to searches. That's it. No explanation needed. No apology needed. No elaboration needed. Say it. Mean it. Stay polite. Stay still. And get home. But here's the question that's been sitting in the back of my mind throughout all of this. We've been talking about the consent search, the moment when the question is asked and you have a clear choice to make. That part is relatively straightforward once you know the phrase. What about the situations where the question never gets asked, where information is gathered, where observations are made, where situations develop in ways that don't look like a search request but have similar implications? Because that happens too, and most people have no idea it's occurring when it is. What counts as a legal search, where those limits are, and how they apply in practical everyday situations, that gets significantly more complex than a simple consent request. And that complexity is what we're getting into next, because understanding it changes how you think about a lot of ordinary moments that most people never connect to their legal protections.